Hey yo, peace, family. Welcome back to Flesh of the Gods. Today we gonna get into the Judge Killer. A little something new. I just want to pop up, get this in while I had a chance. Appreciate y'all. Let's get into it.
That the dastardly sex acts occurred in your chambers. At that point, it was about a 1-minute hearing. And maybe if you read the transcript, it doesn't sound that bad, but Judge Mullins protested and pointedly assured me he could be fair and impartial and he didn't need to recuse. And of course, I had an ethical obligation to my client. I said, I think you should recuse. And Judge Mullins did recuse. It was about a 1-minute hearing.
Friends. They were friends. They had just gone to lunch that day. And today, former Sheriff Mickey Stines is going to be arraigned after he was just indicted by a grand jury for lunch that day. And today, former Sheriff Mickey Stines is going to be arraigned after he was just indicted by a grand jury.
Oh, hold on. Let me switch the screen for y'all. My fault.
For the crime of murder of a public official. The judge he's accused of killing was his longtime friend, Judge Kevin Mullins. And there is surveillance video of the incident. You'll recall this was played in court at the preliminary hearing. You can see the two of them talking, and then you see the sheriff raise up his firearm and shoot. Now, we still don't know the motive. Law enforcement's being really tight-lipped about this, but we know that Stines called his daughter, his minor daughter, from his phone and from the judge's phone right before the shooting. Take a listen. We know that Stines called his daughter, his minor daughter, from his phone and from the judge's phone right before the shooting. Take a listen.
I wasn't present, but when he was taken into custody, I was told by one of the other officers that were there that he made the comment, they're trying to kidnap my wife and kid.
So that's part of their excuse of they trying to use that as him being crazy or evidence of him being crazy, but we all know how that's going. Anyway, they had a hearing today, and I just wanted to air it, so here it go. Appreciate y'all being here. Hit the like, hit the subscribe, tap in, share with a friend. Let's go. Oh, okay.
The grand jury accused.
Hold on, let me switch that. Let me switch the video, family. Hold on. Kind of random pop-up, so excuse the struggle streaming. I wasn't really planning on going live tonight, but I was inspired by this case. It's crazy. All right, here we go. Boom, boom, boom. YouTube. Okay. Here we go. Motions hearing. All right. Alrighty then.
Them to ask for or form their basis for asking for the medical records, Judge. I think that should have been recorded, so we would have that available. And and I think 5.6 requires it, and the remedy is that can form shall form a motion to dismiss, Your Honor. I can address the other area, Judge, or which one? Okay. And the second area, Judge, I really, in candor, I don't, that may need an evidentiary a motion. The remedy is that can form shall form a motion to dismiss.
Did he say child porn? Oh no, child form. Oh, okay. I thought he said child porn. I had to rewind that. My fault.
I can address the other area, Judge, or which one? Okay. And the second area, Judge, I really, in candor, I don't, that may need an evidentiary hearing. It may not. I mean, I'm not sure. Well, I'll leave that to the Commonwealth as to the response to that, but in terms of the other portion.
You're talking about the statements made during the actual grand jury presentation?
Yes, Your Honor.
Okay.
As to the second portion of my motion, it's based upon Commonwealth v. Baker, and Mr. Cox actually handled Mr. Baker in that case. We all know it in the prosecutors community. It's the aluminum bat case. Detective goes in, testifies, and says, basically there was an aluminum bat used. This woman used an aluminum bat. In reality, it was a wooden stick or something like that. And in that case, when the following conviction and an appeal based upon that testimony being misleading, the Supreme Court sent it back and said, look, if you give evidence to a grand jury, you can't mislead. And in this, the bigger debate really seems to be after that, does it rise to prosecutorial misconduct, which should stamp it with prejudice, or is it not? And to me, that falls into the without you represent to the grand jury. And so when I look at the grand jury transcript.
So they making some arguments. I know one of the arguments is they trying to get bond and whatnot. Shout out to Chan My Black is Golden. Shout out to Aaron Adventuring. Shout out to FFS. Shout out to Brown Sugar Babe. I see y'all. Appreciate y'all being here, family. What up though? But yeah, this the sheriff who killed the judge. It's some crazy stuff I got to play coming up. But y'all tap in.
Judge, again, without getting into the KCPC report, one of the big things that bothered me was the grand jurors. First of all, they spent nearly half the time asking questions, and a large portion of those questions concerned the mental health of Mr. Stines. And the last question before the grand jury retires for deliberation was, so he was in a sane mind as far as the investigation has gone, and the answer is yes. That's Detective Stamper testifying. Now, first of all, probably not an appropriate thing for Mr. Stamper, Detective Stamper, to give an opinion on, but the rules of evidence, I get it. I mean, if there's an evidentiary issue, that's not what we're talking about. But here's the thing. If you're going to let a detective testify about sanity and render an opinion, that grand jury takes that to heart. He's seen all these facts. And I submit to you, without getting, I can't reference the report, but I'll say this. You're hard pressed to find much in the way of the investigation that would support the adverse opinion. And so
the absence of evidence is not the evidence of absence.
I submit to you. We gotta have Cat Not Williams gotta play the song. I submit to you. I submit to you. Yo, shout out to today's stream sponsors: Cat Not Williams, Tay Biz, FFS, Chat My Black is Golden. Chan just dropped another 2, said we are here for it. Let's go. Appreciate you, family. Y'all show us some love. Drop her some coins and some witch emojis in the chat.
this is what I believe. I believe that had they not been told by a prosecutorial stamped witness, someone from the government, that he was sane, they wouldn't indict this case. Or at least they might not have indicted on murder. And so what I think, Judge, is if even if the court didn't find that this arises to a level where this case should be dismissed with prejudice, which is what we would ask, at the very least, I think this thing should be remanded back and sent back to the grand jury and let them hear the correct evidence. Would that statement be corrected, or at least take it out? I mean, I don't think they have to put on evidence that's exculpatory for us. And I don't think that it's a, they can let somebody opine to what an expert would say, even if it's a layperson. But if you do that, it can't be wrong. That's a pretty risky thing. And here, the investigation, it definitely didn't show he was in the same mind. And there's other additional issues, Judge, and that's one of the things we want to have the evidentiary hearing for, is to ask about all these statements and what the detective had in terms of the investigation. We want to put that on for the court to show why we believe that that was misleading, in addition to anything else, Judge.
And I do believe you'd agree it would require bad faith for jeopardy to attach.
Yeah, I mean, Judge, I think that in the Baker case, they said it'd be reckless. I mean, it was basically, and I think and I do think it's at least reckless. But I think we need to hear more about what Detective Stamper knew. What he knows now doesn't matter. I get that. It's irrelevant, right? But what he knew the day he testified is very relevant. And you know, I can think of one witness, an attorney, who specifically said, I think he's had a psychotic break. And so to say that your investigation so far is showing us the same mind, yes, I think there's at least enough there, Judge, for let me put the witness up there and ask him.
Right.
And then, Your Honor, there are additional items that I think are also of concern. There's a question.
You cited those in your brief.
I cited those, Judge, and those are additional items. And if the court doesn't want me going about each instance, I'll just say that is the sort of thing that I think we need to know from Detective Stamper. If you knew these things, why did you answer this misleading way? And I think it's reckless at best. And I don't know. We need a hearing to find out, Judge, what I'm asking.
Right.
Unless the court wants to certainly take it under submission and dismiss without an evidentiary hearing, we would request that as well, Judge. But if not, then we'd ask me to put on.
Sure.
Thanks, sir.
Ms. Dahl.
Thank you, Your Honor. Your Honor, the Commonwealth is of the position that we certainly acted in compliance with the rules of criminal procedure here, the rules specifically that were cited by defense counsel. And we would ask that the court to dismiss the motion, to deny the motion to dismiss the indictment as it's wholly without merit. Your Honor, here, counsel is correct in citing Rule 5.06 that we could have unilaterally issued a grand jury subpoena to obtain these mental health records. That is a power that the Commonwealth does have. However, in taking an extra step in the interest of transparency, as a grand jury is an independent investigative body, and to ensure that there was no argument that we were usurping our grand jury subpoena power, we appeared before the grand jury on October 17th of 2024 without a witness, specifically to ask for these mental health records from two different providers for the defendant. We appeared at that time. There was no.
They going crazy with this mental health stuff, but you will see later. You will see why they bringing it up, and you will see how much sense it makes. It's not gonna work. It's not gonna work because they on some bullshit, fighting as hard as they can, ain't they? Starfish and coffee. I see you. What up? Appreciate you joining.
No witness. There was no testimony presented. Counsel again is correct that pursuant to Rule 5.16, had testimony been presented at that time, it should have been recorded and would have been required to be recorded.
Who appeared from the Commonwealth when that request was made?
Myself and Mr. Steele.
Okay.
Only the special prosecutors were present. No witnesses appeared on behalf of the Commonwealth.
Right.
And so, Your Honor, the rule is clear. It requires testimony in order for there to be a requirement for recording. And there was no testimony presented this time. And I think that is apparent. The court now has a copy of the actual recording of the grand jury proceeding for the testimony that was presented on November 21st, the only time that testimony was presented. And I believe a review of that testimony, some of which is referenced in the Commonwealth response that has been filed, will show, based upon the questions that were lodged by the grand jurors, the only thing that was requested at that time were this grand jury subpoenas for those medical records. I think that's reflected in the context of the recording of the grand jury presentation.
And as an officer of the court, are you representing that was the only request made?
I'm sorry, Your Honor.
Are you, as an officer of the court, representing that was the only request made?
Yes.
There was no peripheral commentary or anything of that?
No, Your Honor.
Just
specifically request for those grand jury records, for the mental health records pertaining to the defendant, one from ARH and one for Leslie County Detention Center.
Just a point of clarification, if I understand your question. As you can imagine, nobody in the grand jury room needed to be told what case this was or anything regarding the fact.
I would think that's a safe assumption.
When we went in, we said, we're the special prosecutors in this case. We're here just so we can get a grand jury stand for mental health records. They began asking questions of which we did not have an answer to.
Right.
We never answered any substantive questions other than that. That's something we're looking at. That's part of the investigation. Those matters will be presented to you later. There was never, of course, at this point in time, the preliminary hearing had already been had. The video was already out. Other videos had been released. There was nothing we added at all to, or any conversation regarding the case other than the investigation and why we needed the records. That would have been it.
Go ahead, Mr.
The absence of evidence is not the evidence of absence.
What?
Hey, yo, big shout out to Allie. Allie said, I want my name up there too. Hold on. Put my name up there too. Shout out to Allie with the gifted membership, and Chan My Black is Golden coming through and dropping a gifted membership. Let me scoot these over a little bit. But I appreciate y'all. Y'all showed them some love, dropped them some coins in the chat. I just came to hang out with y'all for a little bit, but we got some stuff to cover, man. This case is kind of wild. I ain't even seen nothing about it yet, but I had to come share it with y'all. Much love, family. Shout out to Allie, and shout out to Chan My Black is Golden. Y'all dropped them some coins. Let me play this other little clip. So this what I'm playing right now is from today. He had a hearing today, basically to see, like, it's like a status hearing to see what's coming up, if he gonna get bond and stuff like that. But also I do have this other clip. I'll get back into that while we getting ready. But appreciate y'all. Y'all showed them some love. Let's go. Oh, I can't double do it. Okay. Oops. My bad, family. Struggle streaming like a mug. Hold on. I got you. Give me a second. All right. Let me shrink this one down and let's play his some of his arrest video.
I can see my daughter in person here before you leave. Is that what you want? At the jail. At the jail. Yep. At the jail, through the screen, on the phone, I want to see my daughter in person. And then after that, I'll tell you everything at that jail. Well, in front of cameras. Video recording. Where's your daughter at? Where's your daughter? How do we track her down? Where's she at? She was at LCC earlier. She was at LCC. I talked to her. So now, Mickey, I want to kind of, for your daughter. Let's talk about this for your daughter, okay? If she finds out that her dad is being arrested for shooting the judge, and she's in high school. I didn't know how old she was, so I didn't know. So she's in high school. What is she, a senior? That's going to be hard. She will want to see me. She will want. Now, come on, guys, be fair to me now. I am being. Y'all going to leave me in here and let me die of Phoenix off? No. I can't get up.
Come on, guys, be fair to me now. I'm one of y'all. What up, Beta Paris? I see you. Appreciate you joining. Hey, listen to this part. You about to be saying a thing, begging for fairness.
In there. Come on now. Come on. I can't. Yeah, man, I can't get him. These cuffs are way too tight. Come on now, guys. Come on now. Keep going. I know it's tight. Keep quiet.
You mean pick your leg up, my brother?
Y'all got carbon monoxide in here.
Oh.
Come on now.
You mean pick your leg up, my brother?
Y'all got carbon monoxide in here.
Oh.
Come on now. Come on. I can't sit like this.
Slide sideways.
I can't. Come on now. Be fair to me.
We're being good to you, brother. You stick your leg up in there.
Come on now, guys. Please don't do this to me.
Come on, guys. Y'all got carbon monoxide in here. Come on, don't do this to me, guys.
Please don't do this to me. Please.
You want to scoot on over a little bit to the left?
Come on now.
Try to scoot on over a little bit more. That way we don't hit you. Can you go any bit farther? I just want to hit you with the door. Put your knee in there, my friend.
Hey, Jason. Hey, Bates. Hey, Bates. Can we loosen this up a little or give the window down?
I'm sorry?
Can we loosen this up a little? Be fair to me, man.
I got some air. I'll crack the window for you, but I can turn the air on back here. Okay?
Yeah. Be fair to me now.
I promise, man. Yeah, I promise.
God, please.
I promise. I'll tell you.
It's hot back here, man. I can't breathe.
as well. So the judge and the sheriff had gone and sat and had lunch together, and then they eventually just made their way back into the office. And the reason that we find this so fascinating is because it doesn't appear.
No. No, he's sleeping.
I'm over here talking on mute. What I was saying was they had just went to lunch together, and this is him right here on the right side. I don't know if y'all can see him. Well, right behind the picture. That's him walking up casually as if nothing is about to happen. That's right before he shot the judge. And yeah, they just came from lunch together.
Judge Ashley, that anything is wrong, it gives no indication of what is about to come.
In that, or said something to someone, and we see
Really shooting Mullins in his chambers following an argument. We've seen the video of this happening. Now we're learning about other alleged crimes that took place in those judicial chambers prior to the shooting.
I have some videotapes of some stuff in the judge's chambers.
What kind of stuff?
Just with girls, sexual and stuff.
What describe? Have you seen the videos?
I've seen one partly, and you know, just them having sex with girls to further be able to get out of jail.
Who was having sex?
Ben and just some higher ups up there.
Who?
The judge and.
Now you saw the video.
Mm-hmm. Yeah.
What did you see on the video? I mean, you.
I mean, I've seen Judge Mullins having sex with a girl.
Who was the girl? Now you saw the video.
Mm-hmm. Yeah.
What did you see on the video? I mean, you.
I mean, I've seen Judge Mullins having sex with a girl.
Seen Judge Mullins having sex with a girl to get them off. So that's just a little clip, just to give you a little sample of some of what we got coming up. We got some of that coming up, but we're going to get back into it, family. Crazy stuff going on here. Dang, my phone blinking. But yeah. I just want to give you a little sample. We're going to keep it rolling. We get back to that in a minute, so y'all can kind of understand where we at. And yeah, so allegedly the judge was messing with his daughter, but I don't know. Y'all be the judge.
And Your Honor, additionally, we asked the grand jury to memorialize what was being requested as far as the grand jury's subpoenas in writing, which was authored by one of the members of the grand jury and signed off on by the foreperson. The verbiage of that is reflected in the response as well, but specifically which records they were requesting and authorizing via grand jury subpoena. So those grand jury subpoenas were issued. The records were received. Those records were then promptly provided to counsel for the defendant on December 4th of 2024 in the very first discovery period. So in compliance with our discovery obligations, Your Honor. So the Commonwealth believes it's clear, based upon the rules of criminal procedure, that we acted in compliance with those rules. We have additional arguments as far as in the Jackson case. However, the Commonwealth does not believe it's necessary to delve into those at this time unless the court would like to hear them as they're reflected in the record.
I've read your motion, or I've read your response.
All right, thank you, Your Honor. So clearly, we do not believe any evidentiary hearing is required with respect to the argument that there was no recording made. That is apparent from the recording that the court already has. So no evidentiary hearing is required. As far as the second argument, turning to the actual content of what transpired and what Detective Stanford testified to and the questions that were asked during his testimony to the grand jury in November. Your Honor, I think defense counsel is conflating the role of a grand jury proceeding with the role of a criminal trial. It is very clear under the law that they are distinctly different proceedings. The grand jury is an investigative body. The Commonwealth has no obligation, as reflected in an abundance of case law, to come in, to present exculpatory evidence, and to attempt to mount a defense for the defendant. That is not the Commonwealth's obligation. Additionally, the rules of evidence, particularly Rule 1101, does not says that the rules of evidence do not apply to grand jury proceedings. So hearsay, opinion testimony, the right to remain silent, all of those things are not required to be adhered to at a grand jury proceeding. If they were, our grand jury proceedings would be the same length as a criminal trial. It's not tenable.
The reason a grand jury proceeding for 30 minutes is the same as a 3-week trial.
Exactly, Your Honor. And so I believe counsel's arguments are confusing the two, the purposes of the two. You know, hearsay is presented routinely at grand jury. Opinion testimony, such as Detective Stamper's testimony, is presented routinely at grand jury. These are commonplace and they are permitted under the law.
You would agree, though, you can't be intentionally misleading.
Absolutely, Your Honor, certainly. And Your Honor, the Commonwealth is of the position that an evidentiary hearing is not required. Everything that transpired when testimony was presented to the grand jury in November is captured on that grand jury recording. The Commonwealth cannot conceive of a reason to haul witnesses in to talk about what transpired because it's on that recording. And so we do not believe that an evidentiary hearing is reported. Or is required, sorry, Your Honor. So, Your Honor, again, the court has that grand jury recording. We would ask that it be filed.
Got 12 watching and 5 likes. Y'all get them likes up for your boy one time. Stop playing with the plan.
Your seal as it was a grand jury proceeding. And we would ask the court to deny the defendant's motion to dismiss the indictment in its entirety without any necessity of an evidentiary hearing. And we would rely on the indictment in its entirety without any necessity of an evidentiary hearing. And we would rely on our pleading submitted as well, Your Honor.
Thank you.
Your Honor, may I just briefly reply? Your Honor?
Yes.
Yeah, Judge, so I mean, I haven't heard anything. I said from the beginning, Judge, I understand, we're talking about the rules of evidence. The reason I cited to the issues where there were things that normally wouldn't come in is because there were instances throughout the grand jury when the witness was about to answer something the grand jury asked for and it was shut down. I was contrasting.
That's not unusual, Mr. Barr.
Oh, I get that, Judge, but my point is this, if you put that into context with what they let testify, then I think ultimately, Judge, if we put on that evidence, will show you that this grand jury was misled. I mean, the statement, to be honest with you, the statement alone, of rendering opinion on sanity is completely, in terms of, I get you don't have to be an expert, Judge, but if you say it, so, I'm not asking you to look at whether things should be admissible. I'm not at all. The grand jury is an investigator, and they don't get to dictate what they hear if the grand jury's asking for additional stuff. So in other words, if they ask a question and it's germane, I'm not talking about relevance, but if it's germane, it's their grand jury. It's not common jury's grand jury. They're the investigative body. And so the reason I cited to the things that I thought should have came in is that it contrasts with other things that I think they asked and never got told because the questions were reformed. That's why I asked you for that.
Well, thankfully, I've been part of about 20,000 cases being presented to a grand jury. I'm going to listen to the recording, and I'll be happy to review that.
And Your Honor, if the Commonwealth
Briefly, sure.
Thank you. I would like to make a distinction. The Baker case, we're talking about misleading to the extent of an aluminum bat
Understood.
versus a wooden stick.
Sure.
I don't think there's nothing even alleged in the pleadings, even if you take everything in the pleadings that's been said today by defense as true, that would be tantamount or even close to that, Your Honor. You know, as far as the mental state of the defendant at the time of the offense, that wasn't even an issue at the juncture of grand jury. That hasn't been raised since by defense counsel. So, Your Honor, again, I don't believe that those arguments are well taken. We would ask that you deny their motion to dismiss in its entirety.
Understood. All right, and I will get an order out on that. One, if I need to hold an evidentiary hearing in it, if not, I'll rule on it appropriately and distribute that. After review, I've got the CDMS Madam Clerk, place that under seal with the conclusion of the hearing. I am going to take a copy of it with me to review for purposes of reviewing the pleadings.
Yes, sure.
All right, next in regards to the bond hearing.
Yes, Your Honor.
Barbara.
Again, Carrie Bartley for Shawn Stines, Judge. And we filed our motion for the court to, it's been back quite a ways now that we filed that, but we did.
So now they getting into the bond hearing.
That's the court to kind of hold.
Which is
off.
not abnormal. I know we've had some procedural things and evaluations, so
Absolutely.
that
And
is something that had to be done.
We asked the court to hold off on setting it for an evidentiary hearing until after we received that report back. Judge, you know, I think by pursuant to criminal rule 440, I believe it is, we're entitled to an evidentiary hearing. I think it's going to be necessary for us to bring witnesses. We had some witnesses lined up. And I think it would be necessary for the court to hear that evidence and make its findings on whether there are several factors by statute.
She looking like Ashley Merchant's sister up in this mud.
The court has to consider when determining whether the bond is appropriate. And there's an added level here, and I anticipate the Commonwealth will argue that Mr. Stines is not entitled to bond because of the way that this case is charged. Okay, so
in that situation, Judge, they're gonna have to put on proof. It's actually their burden to show the court, if that is in fact what they argue, and I don't know, I'm just anticipating, but it is their burden, if they're trying to preclude him from bond at all, to put on proof that guilt is evident, or the proof is essentially, there's great evidence of the proof, right? And so I can anticipate what those arguments are going to be. I can anticipate all of that, Judge. But I think, given what we know, and again, without putting any of that on the record today, given what we know now, I think we'll have a type of an argument on bond.
What would be your proposed bond, in light of circumstances?
Absolutely. And given what his income is, given what he's able to post, and I think that's what the statute requires the court to look at, is what he could reasonably post. We would propose.
Public safety is a factor also.
Absolutely. There are several factors, Judge. I just think that in terms of what the amount would be, the court has to look at what he could reasonably post if he is in fact entitled to a bond. So our proposal, Judge, would be 50,000 cash or property with any non-financial condition.
50,000. She's suggesting $50,000 bond for him shooting and killing a judge. What? How, Sway?
Conditions that the court would require of him. The court could set a host of non-financial conditions, Judge, as you well know. However, I think that given Mr. Stines, and again, without waiving any of our, any of our ability to put on proof, I would ask the court to take a look at the fact that he is, the lowest possible risk level that one human can be in terms of his
pretrial risk assessment. With all candor to all parties, is something that, as a prosecutor, now as a judge, I don't have the utmost faith in.
I understand, Your Honor, but it is also.
And she's still fighting. I mean, I guess that's her job. That's what she's supposed to do. That's crazy, though. Hey, yo, what up, though, Destined to Be? I see you. Appreciate you joining, family.
Something that the statutes require the court to take a look at, and there has to be some other evidence that the Commonwealth can put on, or some other evidence in front of the court that he would be a flight risk, that he would not return to court, that he would be a danger to himself and the community. And again, I think that's why it's important for us to be able to put on proof and to be able to put on some of the stuff that's in that basic piece of report. I think that when we are able to show the court what's in there versus, all the other things, I just don't think there's anything to show that he's a flight risk. There's nothing to convince the court that he would be a danger to himself or others. And I understand why we're here, judges. I get that. But the courts have said consistently, and it's, I believe, the Abraham case, that you have to look at something other than the charge.
I
It has to be
understand.
something else, right? We can't just look at the charge defense.
But that can be factored in.
Absolutely. So, Judge, I think we're going to need that testimony and we're going to need that report. I would ask the court, again, without waiving anything, I would ask the court to consider setting a bond. The court, of course, can do that at any time. And that would be our requested bond, 50,000 cash or property. If the court wants to hear just a little bit about what we would put on, again, Mr. Stines is a member of this community for his entire life, born and raised here. He has a great deal of family support through all of this, as the court can see. He has a wife and daughter that he can still go home to today. He was a member of law enforcement for basically his entire adult life, up until the point of his arrest. He's a respected member of law enforcement, a respected member of the community, and frankly, Judge, everything we've learned about him since then corroborates that. And I would have testimony to that. There's no evidence that he would be a flight risk. Nothing. He has no failure to appear on his record. He has no, property in the Bahamas that he can run off to. There's nothing. This is a man with a great respect for the law, and he's built his life around upholding the law and serving his community. Judge, there's nothing that I've seen, that anyone's seen, and frankly, when we put on our proof of the court will see, there's nothing to say that he would not return to court. There's nothing to say that he would commit another offense. There's nothing to say that everything in this pretrial services report, respectfully to the court, is not correct, that he's a low 0-0 risk, Judge, because this is a man who, again, there's, with all due respect to the court and to everything that, for the reason why we're here, the court does have to look at something other than the offense charged. I know it's a good one.
I understand that, but this, you would have to admit, is a unique fact circumstance.
Absolutely.
This is not a whodunit. The actions are very evident. what the end result of that is, that's the purpose of the case as we're proceeding. So, all right, I understand your argument. Still,
Your Honor, if I may respond, she went through a lot of the statutes. Unfortunately, she forgot the Kentucky Constitution, section 16 says that all people are entitled to bail unless there's a capital offense. And the word she was looking for is the proof is evident, the presumption is great. There's just recently in 2024, a Kentucky Supreme Court case on this issue. It was out of Breckenridge County, if I'm not mistaken. The site on that is 2024 WL 298-2769. That is a case in which, much like we are sitting here today, the defendant was charged with capital offenses. The Commonwealth had made a statement on the record they were not seeking death in that case. That statement made at that point in time, the judge set a bond over the Commonwealth's objection. The Commonwealth then filed appeal on that issue. Supreme Court come back and did the exact analysis they're asking you to do. And basically, what he did in the community, what he did is irrelevant. The only thing that's relevant is, in fact, the charges themselves. And the Supreme Court said, if you are charged with a capital offense, you are not entitled to that. And they overturned the circuit judge and sent it back to the nobody. So there's a case already up at the Supreme Court issued last year. I gave the citation for it. And the case number on that is, or the case name on that one, I don't think I gave you that. It's Commonwealth versus Rodney Jones. And Judge, there's enough in the record already. You can take judicial notice. That's why the Commonwealth introduced the video during the preliminary hearing. It's very clear what happens in the preliminary hearing. They were counsel of record at the time, so there's not an issue. They did cross-examination of that. The record is very clear. The video is very clear.
We got that preliminary hearing he talking about coming up too. I'm gonna play that too. The whole thing for the most part. I might skip past some parts, but I haven't watched it at all. But I'm gonna pull that up next. Appreciate y'all. Let's go.
Clear. And Mr. Stines, in fact, took the life of Mr. Mullins. So that's all that's required. Even under the case law, the Constitution, he is not entitled to it.
No, if I could briefly respond. I do have a piece of case law I can cite here, Judge. It's Burton v. Commonwealth. It is an older case. It's 212 Southwest 2nd, 2010. Judge does show that the court can take into consideration the mental state of the defendant when setting bond in a capital case. So if this case was basically where evidence introduced in a hearing on motion for bail showed defendant to not be guilty of murder, but only voluntary manslaughter, in the event that the jury did not find self-defense, the proof of guilt was not evident, nor the presumption, right? So I think the court can take that mens rea into consideration and that mental health evidence into consideration, which is again why we want to really introduce that.
thank you. In response,
Judge, I believe the case law cited speaks right to the issue.
all right. All right, as with the other issue, like I said, here's what I'm gonna do. Mr. Steele, you said that you all would file a written response on the KCBC evaluation within 10 days.
On a motion to unseal?
Yeah.
Yes, Your Honor.
Why don't we do this? If anybody wishes to submit case law or supplement anything in regards to the pleadings on all three of these matters, if both sides will do it simultaneously within 10 days.
Within 10 days, Your Honor?
Within 10 days.
Yes, Your Honor.
Yes, sir.
And then that'll give us time. I'm gonna try to expedite rulings on this, and then we can start looking realistically more at setting a next hearing. And I think once we get these initial matters addressed, we can then start realistically looking at potential trial date.
Yes, sir.
For all parties. So
one thing, Judge,
Sure.
can we do 10 days for Monday since today's kind of shot? It's
10 days
weekend.
from, why don't we do this, 2 weeks from today?
Yes, Your Honor.
That work?
Yes, Your Honor.
Yes, sir.
Or you want the weekend and add one more Monday?
I'd
Mostly
rather-
your motions.
I'd rather under promise and over deliver, Your Honor.
All right, why don't we do this? And both sides will have till Tuesday, September 2nd.
Yes, Your Honor.
That should give everybody plenty of time.
Thank you, sir.
All right, and then after I get those pleadings, I will notify the parties and we'll get a more realistic timeline on when we'll set the next hearing.
Yes,
All
sir.
right, other than these three matters, I know we have one.
All right. So check this. Crazy, right? The judge was shot by the sheriff. The sheriff went on lunch with the guy and allegedly looked through his phone and found out that he was talking to his daughter. So I don't know if it was they don't know if it was sexual or nothing, but it's hard to tell because they constantly covering everything up. You know, they fight and cover for everything when it's them. The complete opposite they do when it's a regular person, I'll say. But yeah. And then check out these calls though, because it's not the first time that this judge has been accused of some malicious practices. So we're gonna play that call we was playing earlier. Hit that like button, hit that subscribe. Let's go.
Now we're learning about other alleged crimes that took place in those judicial chambers prior to the shooting.
I have some videotapes of some stuff in the judge's chambers.
What kind of stuff?
Just with girls sexual and stuff.
What describe? Have you seen the videos?
I've seen one partly, you know, just them having sex with girls to further be able to get out of jail.
Who was having sex?
Ben and just some higher ups up there.
Who?
The judge and.
Now you saw the video.
Mm-hmm. Yeah.
What did you see on the video? I mean, you.
I mean, I've seen Judge Mullins having sex with a girl.
Who was the girl?
I don't know, because I don't know a lot of people from over there.
Where was it at?
In his office, in the judge's chambers.
Is that the same place that you were meeting Ben? Is that how you know it was a judge in chambers?
Yeah.
And this was Judge who?
Mullins.
But you saw the video of the judge.
Yes.
Any other videos that you actually saw?
No. Mm-mm. They say that the Sheriff Stines is involved. I don't know.
Who said that?
Chad. He said he had videos with Mickey. And Mickey used to do the same thing when he was over house arrest.
Hearing, because we have filed a lawsuit in which we've alleged that the dastardly sex acts occurred in your chambers. At that point, it was about a 1-minute hearing. And if you read the transcript, it doesn't sound that bad, but Judge Mullins protested and pointedly assured me he could be fair and impartial and he didn't need to recuse. And of course, I had an ethical obligation to my client. I said, I think you should recuse. And Judge Mullins did recuse. It was about a 1-minute hearing.
Friends. They were friends. They had just gone to lunch that day. And today, former Sheriff Mickey Stines is going to be arraigned after he was just indicted by a grand jury for lunch that day. And today, former Sheriff Mickey Stines is going to be arraigned after he was just indicted by a grand jury for the crime of murder of a public official. The judge he's accused of killing was his longtime friend, Judge Kevin Mullins. And there is surveillance video of the incident. You'll recall this was played in court at the preliminary hearing. You can see the two of them talking, and then you see the sheriff raise up his firearm and shoot. Now, we still don't know the motive. Law enforcement's being really tight-lipped about this, but we know that Stines called his daughter, his minor daughter, from his phone and from the judge's phone right before the shooting. Take a listen. We know that Stines called his daughter, his minor daughter, from his phone and from the judge's phone right before the shooting. Take a listen.
I wasn't present, but when he was taken into custody, I was told by one of the other officers that were there that he made the comment, they're trying to kidnap my wife and kid.
Is that a portion of the video? Yes, it is. Back over here.
So that was a couple clips. That was the family right there reacting to the shooting video. Crazy, 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 crazy right there. Shout out to our stream sponsors. Chan My Black is golden with the $2. Today's law isn't yesterday's laws. Hey, that's a fact. Things change around here. Y'all get prosecuted too.
The absence of evidence is not the evidence of absence.
What?
MC.
I'm gonna call the case of Commonwealth versus Shawn Stines, 24F 147, on for preliminary hearing. Is the Commonwealth ready?
Yes, Your Honor.
Is the defense ready?
Yes, Your Honor.
All right, call your first witness.
Commonwealth's Clayton Stanford.
All right, so Mr. Stanford, if you would. Raise your right hand for me. Do you swear affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you. You may be seated.
You state your name for the record, please.
Clayton Stanford,
And how do you spell your name?
ClaytonStamper.
Tell the court how you're employed.
I'm sorry.
How are you employed?
I'm a detective with the Kentucky State Police assigned to Post 13 Hazard.
How long have you been employed in that capacity?
I've been with KSP a little over 24 years, detective since 2006.
And have you, in the performance of your duties as detective police, have you investigated the death of Kevin Mullins?
Yes, sir, I did.
And can you tell us on what date that was?
It was September 19th, 2024.
In investigation of that death, were you able to determine who killed Kevin Mullins?
Yes.
And how were you able to do that?
Video surveillance footage.
And did you retrieve the video surveillance footage?
I did.
Here at this time, the Commonwealth move to play video footage.
All right.
Sure, I will object. You can approach.
Yes, approach the bench.
Hold on, let me scrub through, making sure they ain't showing this shoe. Should I put a trigger word? Oh no, they don't show nothing. They don't show nothing. It's cool. It's cool. They might hear it though. I didn't get to hear it on the news clip. Maybe we get to hear it now, because I didn't hear how many shots. It looked like he shot him 3 times. Like he came back and shot him under the desk, but I guess we'll see. Here, let me skip past some of this. Oh no, they got it on mute or what? You motherfuckers. Oh no, here we go. Here you go, here you go. They gonna play it? You gonna play it or not?
Take it as a portion of the video.
Yes, it is.
Oh, it's still no sound. The video must not got sound. Cause that's the clip we just watched with them crying.
And were you able to identify the party that we saw in that video?
That was Sheriff Mickey Stines and Judge Kevin Mullins.
And also, who had the firearm?
Sheriff Stines.
And then Judge was also in his black robe.
Yes.
Do you know what portion of the courthouse that is?
That is the judge's chambers.
And where's that located at, physically located?
In the Letcher County Courthouse.
It's all having on.
Like cross-examine the witness.
Would you? That was a short clip that was played there. How long do you believe that clip was?
That we just watched?
Yes, sir.
Just 10 seconds, 15 seconds.
10, 15 seconds. In fact, the video that was taken in the judge's chambers between the meeting between Sheriff Stines and Judge Mullins, it's my understanding that video lasted much longer, correct?
Yes.
Okay. And have you had an opportunity to review the video?
I have.
Of the prior incident?
I have.
And can you describe for us what happened immediately prior to the clip that we saw?
Sheriff Stines uses his telephone to make some phone calls. He then borrows Judge Mullins' cell phone and appears to make a call on that. And that led to what you just saw.
Okay. So It's my understanding there were, some people who were having a meeting with Judge Mullins prior to the sheriff's entry into the chambers. Is that correct?
Yes.
Have you identified those witnesses?
I don't know the names of them. There's about approximately 4 people in there. Then Sheriff Stines enters the judge's chambers and everybody else clears out.
You don't know their names?
Not right off, no.
Have you prepared a report?
In the process, yes.
You're in the process of preparing a report,
Yes, a lot of information.
but you've not spoken to any of those witnesses?
I'm not directly, but they've all been interviewed. There's recorded interviews of those people in the case.
Okay, so other officers have spoken with those 4 witnesses?
Yes.
And what is your understanding of what those 4 witnesses have said?
Are you in the freak offs?
I don't recall.
You have no idea what they said?
No.
I want to make sure I understand, had there been a hearing previously this day in chambers?
What up, though, Miss DB? Hey, Starfish and Coffee. Oh, not the pizza. Oh, no, not the pizza. Not the pizza club. Only those who know. No pizza over here.
Courtroom?
No, in chambers.
Not that I'm aware of.
Okay. And so there's a video camera that is running in the district judge's chambers. Is that on all the time?
It's my understanding, yes.
Okay. And have you spoken with anyone about why that may be?
No. I mean, there's cameras throughout the courthouse.
Well, fair enough, but are you familiar with district judges' chambers normally, how they're set up?
No. I mean, some of them have video surveillance and some don't.
Right, but
This one does.
generally when they have surveillance, you'd agree with me that that is utilized when there is a proceeding going on in chambers, correct?
It could be, yes.
Okay. And I mean, I'm just asking, so this video didn't have an audio recording to it, correct?
There's no audio.
Outside of once the 4 people that were inside that we don't know their names, once these 4 people had left the chambers.
And so real quick, y'all, I got a question, right? So if this been happening and they got videos and the witness said she's seen videos from him in his chambers having sex with people and whatnot, then why have he never been like in trouble before? Why who's covering this up? That had to be a RICO or something, because somebody got to be watching these videos. How did some average person end up seeing the video, but the people who's supposed to be running the courts ain't seen a video of him having sex with people? And this ain't the first time he been not convinced. What is it? People said he did that. They claimed that he did that multiple times. So it's not the first time. Have y'all never looked at the tapes?
Were they in an area adjacent where they could hear anything that was going on?
Yes, I believe some of them did remain.
He got his own Diddy tapes. We need to pull up the Diddy files. He got some Diddy files too. Pull them up. I don't want to see them, but we need to know that they exist.
In the next room.
Okay. And what did they tell us?
Do what?
What did they hear?
I've not been I wasn't part of those interviews.
Okay, so if I'm understanding correctly, you're prepared for a preliminary hearing on a murder, and there are witnesses in an adjacent room.
I mean, they heard gunshots.
Now, please, my question, please.
Yeah, let him ask the question.
Thank you, officer. So you are
Allegations. All right, I'll take that one. Appreciate you.
Are investigating a murder and testifying in a preliminary hearing, and there are witnesses who may have overheard what preceded this edited clip, yet you can't tell us today anything that they said?
I've not personally listened to those interviews. I've talked to the other officers that did those interviews.
Fair enough. And I mean, we're here at a preliminary hearing, as you know, that you can testify to hearsay. I'm asking you what they said.
They heard gunshots.
Okay. Was there any statements that we overheard?
No.
Were there raised voices?
There, one person stated that she didn't recognize him as being Judge Mullins' voice, but heard somebody say, "Help, help."
Presumably that would be after the firearm was drawn or shot.
Objection, Your Honor.
I withdraw, Judge. Okay. So is there any testimony that you can give us today about any statements or arguments or the content of that argument prior to the shooting?
No.
They changed the camera for the cough real quick. Hey, hold on. Aaron Adventurer said, FOTG, you should look up Roger Golubsky. He used to do this in his office at the Kansas City KSPD on camera, and multiple people walked in. Others didn't report it. Nobody believed victims for 30 years. So I will look into that. But if y'all want to get a jump start, y'all go check that out. That's crazy. Out in Kansas City. That's, oh no, they in Kentucky right here. Well, that's still Kentucky. Well, yeah, right? I think they in Kansas. I think they in Kentucky. Let me check. He said,
I want to ask generally, so did you process the scene?
Shit, this one in Kentucky too. They both in Kentucky then. Okay, that's crazy. Oh, Kansas City, Missouri. Okay, there you go. I don't know, man. I don't travel a lot.
You the lead investigator on this case?
I am.
Okay, so as a lead investigator, I would presume that you would have secured the chambers and evidence once you arrived.
I was part of that, yes.
You were part of it, right? But you were the lead investigator, so you'd be in charge of those duties and delegating what should be done. Is that fair?
No, I don't delegate what's done.
Okay, so you're the lead investigator. What does that mean?
I'm the case officer.
Okay, so you're carrying the case. So I want to make sure I understand, had Judge Mullins been removed from chambers when you arrived?
No.
Were you able to ascertain, did he have a firearm on his person?
We did not locate one.
You did not locate one?
No, there's not one in the chambers.
Okay. And there was none on his person?
No.
Okay. All right. Who was the first person to arrive on behalf of law enforcement to investigate?
They were already in the courthouse.
Fair enough, but I'm talking about in terms of people that we may see a report from or take part in this investigation. Who would be the first person that we get?
I believe Trooper Jason Bates was the first KSP personnel on scene.
Okay. And you spoke with him and
I did.
And he searched and did not locate a firearm?
No, he didn't search the scene, no.
His
role at that point was security of the scene.
I understand, but I'm just trying to ascertain, you said earlier that there was no firearm found.
No.
I'm wanting to know, can you tell us, was it specifically searched for a firearm?
In the judge's chambers?
Yes, sir.
There was myself, Detective Chris Collins, Detective Scott Caldwell, Detective Eric Caldwell. That's all I recall right now.
Okay, but I'm trying to understand, so who searched specifically for a firearm?
We all did.
And that was specifically something you looked for?
Yes.
Fair enough, okay. Of course, your investigation, did you ascertain that prior in the day, there had been a lunch meeting between Sheriff Stines and Judge Mullins?
There was.
Pardon?
There was.
Okay, sorry.
Real quick, shout out to Starfish and Coffee. Said Hillbilly Crime has extended videos and depositions. I'm gonna have to check it out. I looked at a little bit of clips. It is some good stuff it's looking like over there. I'm gonna have to check it out. Hillbilly Crime. So there go another one. I'll drop the link if I could grab it.
Someone, I couldn't hear your response. I wasn't being trite. So where did this take place?
It's a restaurant called Street Side, and it's just down the street from the courthouse.
Okay. And it's my understanding there were a couple of other people who attended the luncheon?
There were several, yes.
Okay. And at some point after that, they wrapped up lunch, and left, obviously, and went back to the courthouse. Are you aware of anything so far in your investigation that would tell us there was any issues at lunch between Judge
No,
Mullins and Sheriff Stines?
no.
Okay. But someone on behalf of the KSB has spoken to those witnesses?
Yes, they've all been interviewed.
And there was nothing unusual that had arisen during that luncheon?
I was told that the judge made a statement to Mickey about, do we need to meet private in my chambers? That's all I was told.
Do you know the context of
I do
what the conversation was before that they would need to discuss in chambers?
I do not.
So it's my understanding that in the larger portion of the video that we haven't had access to, that there is a point when Sheriff Stines asked for to see the telephone of Judge Mullins.
Yes.
Is that a yes? I mean,
Yes.
yes, okay. And I would presume that you and the other officers you mentioned, when you secured the scene, that you secured those phones as well. Is that correct?
Yes.
And have you reviewed both of those phones?
They're currently at the forensic lab at this time being downloaded. I have had discussions with the people at the lab regarding the downloads.
And those are a couple of other questions that I was going to ask you, but my original question was, have you reviewed or are you aware of the content of the phones?
I've not personally seen it because I've not received those reports yet.
Okay, again, based upon your conversations with the officers, are you aware of any recent content that was up and could have been relevant at the time of their discussion?
I was told that Sheriff Stines had tried to call his daughter, and he had tried to call his daughter from the judge's phone also.
So, have you obtained the phone records from Judge Mullins's phone?
I don't have those in my possession yet. No.
Okay, have you issued a search warrant for them?
Yes.
Okay. And have officers confirmed that the sheriff's daughter's phone number was on Judge Mullins's phone?
Yes.
Okay.
So, yes.
So that number had been called from Judge Mullins's phone. Is
Yes.
that correct?
Yes.
Okay. So we don't have a viewing of what transpired during that exchange of phones. But based upon your review of those moments prior to, when Sheriff Stines observes that cell phone, was he previously seated?
Yes.
Okay, so in the clip we saw, he was standing the entire time.
He was seated in front of the judge's desk.
And he looks at the cell phone. What is it? Can you describe his reaction in the video that we haven't seen?
Whose reaction?
Well, the sheriff.
You can't see his face in the video.
Okay, but is it clear that?
You are a liar.
Does it appear to you that? Let me rephrase this. Did he stand up after
Yes.
looking at the phone?
He stood up.
And how long after he looked at the cell phone and stood up did this occur that you played?
Just seconds.
Did you make the decision as on edits today for what you were going to present? In terms of, did you make the edit or determine which portion of the video we were going to see today?
No, sir, I did not.
Okay. Both cell phones have been sent to the Kentucky State Police forensic team, is that correct?
Yes.
Have you gotten any early report on what was found?
No.
Okay. Were both phones still on the desk when you arrived?
The judge's phone was on the desk. Sheriff Stein's phone was on his person.
Okay, so, are there photographs of, was the phone locked at that point or was it still open?
So hypothetically speaking, to me it sounds like his daughter might have gotten some trouble. Police pulled her over, whatever, whatnot. She was like, call my uncle or my stepdad or whoever the fuck she calling the judge. She was like, call the judge. I know the judge. He called the judge. She was like, bring her to my office. They brought her down to the office. Once they got to the office, he was like, you want to go jail or you want to go home? He hit her with, you want to go jail? You want to go home? And that's probably how it all started. And old boy probably found out. So, I don't know. I'm just allegedly.
With both of you, asking about both of them, or?
Well, first, let's talk about, that's fair. First, I'm talking about Judge Mullins, since it was the one that was still on the desk and presumably nobody touched it prior to you securing it, correct?
No.
So, yeah, so I would like to know about that. Have you ascertained what was currently open on that cell phone?
No, I don't know at this point. No.
You don't know?
No.
Okay, do you think that will be important to learn?
I hope to learn that when the report's ready, yes.
Okay. But as of today, you can't tell us what was currently open on the judge's file?
No, sir.
Did you conduct an interview with Sheriff Shawn's daughter?
I did not, but she has been interviewed.
Are you aware of who was present when she was interviewed?
Lieutenant Randy Combs and Detective Anthony Trotter.
Okay. And she was interviewed with or without her parent?
With.
So her parent was present at the time you.
So basically the argument is, wouldn't you go shoot somebody if you found out they was messing with your underage daughter? Especially a friend of the family, supposed to be older, father type, uncle type figure, and he messing with your daughter. Wouldn't you go shoot him? That should be okay then, right? That should be okay when everybody do it, not just the judge though. That's the thing.
Interviewed her?
Yes, I believe. I wasn't there, but yes, I think so.
The law enforcement has not spoken to her without her parent present?
Not that I'm aware of.
Okay. Did the Kentucky State Police obtain her phone?
I mean the sheriff.
You intend to obtain records for her cell phone number?
Possibly, yes.
Do you believe that that will be soon that you'll do that?
Could be, yes.
Okay. Had you already intended to do that or did you just respond to my question?
Well, the call should be on the judge's records too.
Well, I understand.
And she's made statements about what occurred during those conversations.
I understand that, but I would presume that, have you ascertained whether Judge Mullins also had apps that stand outside of phone records?
I've not received those records yet. I don't know what's on the phone.
Fair enough, but I mean, did you look at the phone? Did it appear there were apps on it?
I'm not the person that's qualified to look through the phone.
Okay, but you're familiar with cell phones. They can host other forms of communication.
Hold on.
Yes, sir.
What's the
He's
objection?
been asked and answered, Your Honor. He's asked a question, I think about 4 or 5 different ways. The officers, the detective repeatedly said that he does not have a report with phones. He's not good at the phone. He can't testify that matter.
I should
Let him ask the question, and what he can only testify what he has personal knowledge about.
Absolutely. Yes, sir. Thank you, Your Honor. So you're aware that phones can be used for apps such as Facebook?
Yes.
Okay. And that is not something that is captured by cell phone records. You would agree with me?
I agree.
Okay. So in light of that, although the records may be mutually the same, right, the same between Judge Mullins' phone and the sheriff's daughter, do you believe that you could also ascertain other information from the cell phone app content?
Are you asking what apps are on the phone?
Yes, well, that was my original question.
I
but
don't know
thought you didn't know.
without, I've not received that report yet. I don't know what apps he had downloaded on the phone.
If he has social media apps, do you intend to?
That could lead to additional search warrants, yes.
If you would, officer, please let me finish before you move forward, and I'll try to slow down a little bit as well, okay?
Sure.
Thank you, Trooper. Have you determined whether there were any previous issues, personal or professional, between Sheriff Stines and Judge Mullins?
I've heard things.
What have you heard?
Just that this regarding the lawsuit that the Letcher County Sheriff's Office is currently involved with.
Okay. The lawsuit that involved ultimately a criminal conviction of a deputy for sexual behavior in the judge's chambers. Is that the one you're referring to?
Yes.
Okay, and this.
Yes, the ones that y'all know about. So y'all already know this was happening. Why y'all ain't do nothing about it? Y'all been knew this was happening. What up, Cha Diggy in the building? I see you. Appreciate you joining, family. For always, forever, for life. What up, though? Hey, I got it right that time, man. I be tripping and fumbling all over your name. I got it, though. For always, forever, for life. What up, though? Let's get it.
Subject matter of that lawsuit, the chambers area, that's the same chambers in which this occurred. Is that correct?
I'm not familiar with the details of that case that the lawsuit resulted from.
Okay. Are you aware of any criminal reports that Sheriff Stines had made of Judge Mullins prior to this day?
No.
Did you personally observe Sheriff Stines following this video?
Did I personally observe him? What?
Did you meet with him? Did you talk to him after?
He was in custody when I arrived at the courthouse that afternoon.
And at some point, did you draw any observation about his demeanor?
He was mostly calm, I thought. I mean, I talked to him, but he didn't say nothing about why this had happened. But he was calm. He was kind of afraid that basically all I said was, treat me fair. That's basically the comments he made.
Okay. Did he also make a statement about, I don't see it in the citation here, but somewhere along the line I saw a statement being attributed to him about protecting his family?
I wasn't present, but when he was taken into custody, I was told by one of the other officers that were there that he made the comment, they're trying to kidnap my wife and kid.
Have you ascertained any evidence that this
A nice surprise.
shooting was pre-planned?
No.
Okay.
Not at this time.
And would you agree that from what we've seen so far, from the evidence you've seen so far, the shooting was a reaction to what was on that cell phone in that moment? Is that accurate?
Objection, Your Honor. Also speculation outside of his scope of expertise.
Your Honor, I believe that if he has formed an opinion about the investigation up to this point, especially at a preliminary hearing, he could speculate on that, Judge.
Well, she's saying.
Sure. So, is there anything other than the content of the phone that this video will reveal to us about why this took place?
No,
Does it appear that this took place as a reaction to what was happening in the chambers at that point?
I can say it occurred after a phone call was made. I don't know what was said or nothing like that, but
Fair enough, and I'm not asking you the content of any of that, but at this point, is it your theory that whatever that content was in the discussion was the impetus of the shooting?
it could be, but I don't know that for a fact.
Okay. Do you have any evidence up until this point that you have developed that would demonstrate that it was not as a reaction to what was on the phone?
No,
None whatsoever?
no.
Okay.
He said, nah.
Judge, if I had just one moment to confer with the council.
The absence of evidence is not the evidence of absence.
What?
Shout out to today's stream sponsors: Cat Knot Williams, Tate Biz TV, Ali, Chamar Black is Golden, FFS. Appreciate y'all, family. We almost up out of here. Let me see. Actually, I do got another clip, but they ain't done yet. They ain't done yet. It ain't over yet. They just having a sidebar. Let me skip past some of that. Appreciate y'all though. Y'all
Did you
show those
attempt
love.
to speak to Sheriff Stines at the Leslie County Jail after the incident?
No,
Did anyone from your agency attempt to interview him?
not to my knowledge, no.
And at that point, had he asserted his right to an attorney or anything?
No,
But nobody went back to try to talk to him or do an interview?
no.
Yeah. I think I have one other question. In addition to cell phones that we've discussed, the cell phone of Sheriff Stines and the cell phone that you found of Judge Mullins, were there additional phones that you were able to obtain?
There was one other phone that's currently being examined, and the basic reason it was seized was there was a text conversation between Sheriff Stines and some of his employees with the sheriff's office.
The evidence is going to show that anything that I may have said, they exacerbated it.
That was an additional phone of Sheriff Stines.
It was a phone of, I guess she's the, I don't know what her title is, but she's employed. She's not sworn. She's employed by the Letcher County Sheriff's Office. And she voluntarily gave her phone to the person that interviewed her.
Okay, and just out of curiosity, could you explain why that was relevant or germane to your investigation?
I didn't conduct that interview, but it was, I guess it was regarding the dinner at Streetside and things that led up to the shooting. But I don't have those results either, so I don't know exactly what was said.
Correct me if I'm wrong. I thought when we discussed that earlier that you indicated there was no evidence that the conversations at the lunch.
I haven't seen those conversations yet. I've not received downloads from the phone.
Right, but
Man, this dude trolling. Ain't he supposed to be the lead investigator? How, Sway? You trolling. Talk about, I ain't seen this, I ain't seen that, I ain't got the phone, I ain't got the downloads, I ain't got nothing. What the hell, Bobby?
ask you if you're aware of any information that could have been gleaned from witnesses at that meeting. And as I recall, you said no, but there is some information that something was discussed at this lunch. Is that correct?
I don't know what was discussed at lunch.
I understand, but you obtained this lady that we don't know her name. You obtained her phone in an effort or based on a belief that she would be able to demonstrate what was said at lunch. So you would agree with me, you believe that there is a witness or information that may have popped up at lunch?
There's a recorded interview with her in the case, and I'm yet to receive the downloads of the phone, so I don't know what they contain.
Okay, well, has that phone been sent to for
It is.
forensic examination as well?
Yes.
All right, thank you. Officer, that's all I have. Thank you.
Mr. Williams. Is Judge Mullins, he sent to medical examiner's officer in autopsy.
He was.
Have you received that report yet?
No.
Have you had informal conversations with him regarding his cause of death?
Yes.
And what was that?
Multiple gunshot wounds.
The video we showed earlier, that a true and accurate copy of what you received?
Yes.
Concluded it is called exhibit 1, Your Honor.
Any objection?
Your Honor, I'd ask, of course, all we saw today was the clip, but I asked it to be admitted in its entirety, and I'm going to
I'm going to respond to that.
Judge, I'm only think preliminary here is required for probable cause. This establishes probable cause. I think the entire clip is outside the purview of the these proceedings today.
I think if you're going to want to see the whole video, she objected earlier. I'll admit it. It was short earlier. That was the clerk. We read as a shut it.
Hey, Detective, this is an ongoing investigation.
Yes, it is.
And as this ongoing investigation proceeds, you will be interviewing more people if necessary, submitting more evidence to the lab.
Yes.
That's all I have. Your
Recross. All right. Any other witnesses for the Commonwealth?
No, nothing further.
All right, you may speak. Any witnesses for the defendant?
There you are.
I'll find probable cause and find this case over the grand jury. Anything else? Anything else before we turn forward?
Yeah, yes, Your Honor, there's no, we're not allowed to sum up, Judge, what?
Well, if you want to make an argument, sure.
But it sounds like I may change your mind, Judge.
There's a probable cause hearing, so, but yes.
I understand.
Take your best shot.
Thank you, Your Honor. Well, so, murder under our statute, as the court knows, and I'm not telling you anything you don't know, but if there is an issue as to extreme emotional disturbance, then there has to be some evidence that would rebut that. And specifically, when I asked the witness today if there was any evidence to rebut that this occurred as a direct result in the moment of this observation, I don't have none at this point. And I get it's just probable cause, but I think they've established probable cause for manslaughter first, but not murder. Because I've heard nothing that indicates that this is not, an example of an extreme emotional disturbance relative to the phone. At any rate, Judge, respectfully, I understand the court's previous ruling, but I did want to address that with you.
That's fine.
Thank you, Your Honor.
I'm going to respond.
Thank you, Your Honor. Extreme emotional disturbance is a defense. There's not been a defense presented here at this court today. The evidence presented in this court today is that the judge was intentionally shot and killed, shot multiple times by the sheriff, and there's probable cause to find the grand jury murder charge.
Yeah, I agree. There's probable cause to proceed.
Yes, Your Honor.
All right. Anything else before we adjourn court today?
Your Honor, in terms of, we'd like to discuss, if we could, lodging from here where he's transported. Is it the court's intention to have him take, and I don't want to discuss that potentially publicly, Your Honor.
I'm not sure I can make that, help you on that.
Sure. So,
I mean, we could, you're welcome to staff report and discuss that. I'm not sure I can tell them.
Sure. So the transport order that was entered that will direct Sheriff Stines to go back to where he came from, Judge. Is that fair?
Let's adjourn court and we'll talk about that.
Yes, sir.
I don't know that I can change where he's going to be at.
I'm sure. Yes, sir.
We can discuss it. All right.
Excellent.
All right. Court's adjourned.
Yes, sir.
I will say this, I do agree that the Commonwealth can, their legal advice to the grand jury and the grand jury deliberations do not have to be transcribed. But whatever was said to the grand jury, that cued them to ask for or form their basis for asking for the medical records, Judge. I think that should have been recorded, so we would have that available. And you know, and I think 5.6 requires it, and the remedy is that conformity shall form a motion to dismiss, Your Honor. I can address the other area, Judge, or okay. And the second area, Judge, I really, in candor, I don't. That may need an evidentiary hearing. It may not. I mean, I'm not sure.
Shout out to everybody in the chat. Appreciate y'all showing up, showing out. Much love, much love. Shout out to Cha Diggy. Shout out to FFS. Shout out to For Always, Forever, For Life. Appreciate y'all being here. Shout out to Starfish and Coffee. Much love, much love. Shout out to Chant My Black is Golden. Shout out to Beta Paris. Appreciate you, family. Shout out to Starfish and Coffee. Oh, I think I just said that. I'm seeing doubles already. Shout out to Miss DB. I see you, family. Shout out to our stream sponsors of the night. Y'all show them some love. Shout out to Allie. Shout out to Cat Knot Williams. Hey, hold on, Tat Cloud. What the what? I see her name up there now. I didn't see her in the chat. I must have missed that part. It must have just been in the beginning. My bad. Well, what up, Tat Tat Tat? I didn't see that in the beginning. That's my fault. That's my fault. I don't know what happened. I was still setting up. I was getting my steps together. But anyway, I appreciate y'all. Y'all showed them all some love. Shout out to everybody. Much love, much love. Until next time, family. Stay fresh and stay blessed.
No.
¿Qué puñetas? ¿Qué puñetas? ¿Qué puñetas? ¿Qué puñetas? ¿Qué puñetas? ¿Qué puñetas?